Today, the Union government has passed a notification under the Union Home Ministry extending the validity of disturbed area designation and in line Armed Forces Special Power Act of 1958 over 3 states in Northeast India. What happened is, in the 3 states of Arunachal Pradesh, Manipur and Nagaland, AFSPA has been extended for a period of nearly next 6 months. In total, in the Northeast India, 4 states are present currently under AFSPA, that is Assam, Nagaland, Manipur and Arunachal Pradesh. And in these 4 states, some sections of the state region is designated as a disturbed area. And right now, even in the Union Territory of Jammu and Kashmir also, there is an AFSPA which is in force. Let's try to understand what is a disturbed area, who can notify a disturbed area, who can revoke the designation of a disturbed area, what are the special powers under Armed Forces Special Power Act which are given to the armed forces. Let's try to analyze. And if you look at it, the Armed Forces Special Power Act was passed in the year 1958 in order to control the insurgency which was happening in the region of Nagas, which was then part of the state of Assam. So a region of Naga dominated region, it went for insurgency, and the state police in Assam were unable to control the insurgency in the region, primarily because they had more advanced weapons than the state police, and they were having, in fact, regiments in the lines of the in the military, and along with having regiments in line of military, they are also in fact conducting guerrilla operations against the state police, and the state police were in no capacity to control the region. So naturally, what the Union government did at that point of time is, it declared the region of the Naga Hills as a disturbed area because the state police are unable to control the region, and sent the armed forces there in aid of the state police in order to maintain the public order. And from then on, multiple states across India, ranging from Punjab to all the states of Northeast India to Jammu and Kashmir, at different points of time have been put under Armed Forces Special Power Act. And if you look at the fine line of the Armed Forces Special Power Act, the designation of a disturbed area can either be made by the state governor or by the Union Home Minister as a representative of the central government. Both of them can declare any area as a disturbed area. And just before the declaration, they have to consult the state's opinion, but the state's opinion is not binding on the central government. Then apart from that, if you want to revoke AFSPA from any particular region, then usually the central government has the powers to revoke AFSPA, and the governor at best can recommend to the center in order to revoke AFSPA, but the final decision would be under the control of Union Home Government. And if you look at the fine line of AFSPA, in fact, once the armed forces enter into any disturbed area, they have the right to stop any public gathering of 4 or more people. That is very similar to section 144. Then over and above that, the armed forces get the right to search and seize any house or vehicle. So without any warrant, they can do it. And they can also go ahead and arrest any person without warrant and detain him. But there is a provision in AFSPA that the person who has been detained or arrested should be surrendered in the nearest police station with the least possible delay. But unfortunately, the least possible delay has not been clearly defined, leading the armed forces to detain people for extended period, sometimes leading to the problem of missing persons in the region where the AFSPA is in force. Then apart from that, the armed forces has a draconian provision which is called as the use of force. In fact, under the provisions of the Act, an armed forces personnel can use the force to the extent of causing a death of a person after giving due warning. After giving due warning, if any person is in contravention of law, the armed forces personnel, they get the right to shoot the person in order to kill him. In fact, this is considered to be the right to kill provision. So, and this is a very extreme provision in Armed Forces Special Power Act. Then over and above this, one more extraordinary provision that is given to the armed forces personnel is, for any act of force that has been done by the armed forces personnel, there cannot be any prosecution. It means that no judge or judiciary can take cognizance of this offense, and in fact prosecute the person who is responsible for an atrocity, primarily because only with the central government's express permission only prosecution can be started against an armed forces personnel. See how draconian it is. The armed forces personnel can kill a person, but no FIR can be lodged against them. No prosecution can be conducted against them in any judiciary. They will be only subject to the military courts. It is giving, in fact, a kind of exception to the protections which are present under the constitution. In fact, our constitution provides a lot of protections to people under it against the state action, but the Armed Forces Special Power Act removes these protections against state action. And this extraordinary powers given to the armed forces personnel in many cases has led to a cycle of violence. So the armed forces will conduct some violence, the insurgents will get more legitimacy, they will start fighting against the armed forces personnel, more violence, and then counter violence by the insurgency groups. This led to a cycle of violence in Northeast India and Jammu and Kashmir and in the state of Nagaland from 1958 on. That is nearly 70 years. Okay, AFSPA is still in force in the state of Nagaland. And there were many charges and counter charges about the excesses done by the armed forces personnel in the state of Manipur after the killing of an young lady by the name of Manorama, Arunachal Sharmila. She went on a hunger strike which has lasted for 15 years. Then nearly 1,500 people were missing in the state of Manipur after the imposition of AFSPA. This led some people to form an association which is called as Extrajudicial Execution Victims Family Association, and they went to the Supreme Court of India. And in fact, in this judgment, the Supreme Court has clearly stated that the armed forces personnel should be held responsible for disproportionate use of force. It means that if they use excess force in any case, they should be held responsible for the same, and the state police are responsible in order to file an FIR against the armed forces personnel is also one more provision which has been given. But quite unfortunately, till date, very few FIRs have been filed. Then over and above that, the Supreme Court said that the armed forces personnel are not above the rule of law, and they also should subject to the same law provisions which are applicable to others too, and they should not create an extrajudicial mechanism of their own is the numerous observations which are made by the Supreme Court. But till the date, there has been no reform. Even a committee appointed by the central government called BP Jeevan Reddy Committee, it also recommended the revocal of AFSPA and asked the union government, in fact, to add an additional chapter to Unlawful Activities Prevention Act in order to deal with the insurgency prone areas rather than having a special act for it. Then over and above that, even UN also on multiple occasions, particularly UN Human Rights Commission, said that the AFSPA is a draconian law which should be revoked in India in order to protect the democratic values. So this way, there is a long overdue need for reform in AFSPA, but the armed forces personnel claim that because of their morale, because of the operational efficiency reasons, AFSPA should continue. So we have to leave it to the discretion of the union government whether to continue with AFSPA or to revoke it. But whatever the decision is taken, it should be in the interest of national security, unity and integrity of India without compromising the human rights. A fine balance need to be established. Thank you.